discussing four important aspects under that. The first one would be relief for the corporate sector under force majeure or act of God and what it is. I shall be talking about the impact the COVID situation has on rental obligations, which is again a major concern for a lot of people. Then I shall be talking about employment related concerns in light of the COVID-19 situation. And finally, we would be discussing in brief the insolvency landscape in India as it stands today after the increase in the threshold of default. So to begin with, we'll start with the relief for the corporate sector under force majeure. Now, looking at the current situation and the lockdown, a lot of corporates, a lot of companies, as well as employees and individuals are looking at their individual contracts to see if they have a force majeure clause and how they could invoke the force majeure clause to either suspend or terminate their respective obligations. So before we come to that, what is force majeure? What is the meaning of force majeure? Now, the concept of force majeure originated in France, which literally translates into a superior force. That's why act of God. So what it means is whenever such an event happens or occurs, which is beyond the control of the respective parties, and because of which the parties are unable to perform their obligations under the contract, either parties or the affected party can invoke the force majeure clause present in the contract to either suspend his obligations or set aside the contract altogether, depending on the situation and conditions. Now, examples of force majeure events are natural events or calamities like earthquakes, you have floods, you have pandemics or epidemics like coronavirus. You also have events like union strikes, wars. You can also have government orders and actions like the current lockdown. So it can have various events under the ambit of force majeure. Now, to begin with, what one must look for in a contract when dealing with force majeure. Now, what is important to see is are three main things. One, whether there is a force majeure clause in your agreement. Second important thing is whether the definition of force majeure is inclusive and covers events like the current pandemic or government lockdown. Third, what is important is whether the force majeure event makes it impossible for the party to perform its obligations under the contract, even after genuine attempts to perform the contract. Now, this is important. The parties have to take genuine efforts to make sure they can perform. They should not just give away like citing force majeure. If the above criteria is satisfied, then either of the parties or the affected parties can invoke force majeure clause and either suspend its obligations until such further time as may be agreed, or altogether terminate and set aside the contract depending on the situation. Now, what is important to note in this scenario is that commercial hardship or financial inconvenience is not enough to trigger force majeure. The event must be such that the performance altogether cannot be possible. So only if there is a financial difficulty that is not good enough for a force majeure event to be invoked. For example, say two parties have entered a contract for purchase of sale of essential commodities, and in the current scenario, the government has permitted purchase and sale of essential commodities. So neither party can cite just financial inconvenience and invoke force majeure to not perform their obligations. Then we come to what is to be seen about the definition of force majeure. There are two important things which you have to see at the time of invoking force majeure events. One, you have to is constructed in such a way that gods, which may not be mentioned in the agreement itself. Second scenario, the party events which are mentioned in the agreement, other event which is not included will not be considered as a force majeure event. So it is very important to have a proper construction of the force majeure clause at the time of entering into the contract, and also at the time of invoking, you have to be sure you are following the force majeure clause. Like let's have an example. this is an illustration. Force majeure means any event, including acts of God or such other events beyond the reasonable control of and not attributable to the affected party. Now, this particular construction is a very wide construction of a force majeure clause, which could be a part of any contract. Now, in this scenario, even the current epidemic, corona pandemic that we are facing, or the lockdown of the government, ordered by the government, can be included as a force majeure clause to get rid of to suspend the performance of the contract. Okay, I don't know why that line is coming, but okay. Then we move to how to invoke force majeure clause. Now, these are important steps which one must follow at the time of invocation of force majeure clause. Now, please note that you have to be, the first one is be specific at the time of incorporation as well as invocation, which means when you are entering into a contract, make sure you have proper legal guidance and you have properly constructed the force majeure clause to deal with events even like pandemic or language which can be interpreted in more than one way, because that would only give a loophole to the other party to dispute or refute the invocation. Second is follow the terms strictly. Now, what happens is every force majeure clause, or most of them, have a particular method of invocation, which some clauses may have a particular time frame for giving an advance notice to the other party. So make sure that time frame is followed. Some clauses may say suspension is mandatory before termination. So make sure you're following the suspension clause and not directly jumping to terminating the agreement, because that would be bad in law. Third is do not delay in invoking force majeure clause. Now, whenever there is a delay in any transaction, it is looked upon in bad light. It is looked upon as an afterthought, and it would only create a dispute between you and your counterparty. So make sure whenever there is such an event, you take the proper steps, proper legal advice, and do the proper things necessary at the right time. Then what is important is that ensure the notice is received. Now, as invocation is important, timely invocation is important, so is the receipt of notice by the other party. So you have to make sure, normally all commercial contracts, they have communication clauses which have provided for some registered addresses where notices could be sent. Some clauses have email communications as one of the methods. Now, looking at the current lockdown and this unprecedented event, it is very important to have email correspondence included as mandatory in your contract. So make sure this is followed properly. Your force majeure invocation notice is very important. It's a very important document. So you should seek proper legal advice and make sure that the language is clear, and you should not go ahead invoking force majeure without seeking advice. What if the other party disputes the disputes? So it is obviously it is a given situation that not always the other party would be fine with you invoking force majeure and setting aside your obligations. They may be
Nihar,
may be a dispute by the other side.
Nihar.
So in such a scenario, it is very important to reach a mutual understanding. Also, at this stage. Yes. Yes.
Nihar, your voice
Hello?
breaking seems.
Yes, can you hear me?
You're facing some network issue.
Now, can you hear me now?
Yeah, but the voice is cracking. I suggest you turn off your video and try once, so your audio will become better.
Okay.
Yeah. Okay.
How about now?
Yeah. So now I think it should get better.
Okay. Okay. Also, there are some lines coming on my PPT. I don't know what those lines are, but nevertheless.
Somebody has touched their cell phone, unfortunately, and somebody will, so that they'll have to figure out who's done that.
Okay. Anyway, so like I was saying, notice and correspondence are very crucial. Also, if the other party disputes, the best thing to do is to reach a mutual understanding where suppose there's a possibility of only suspension, then suspend the contract until such further time. it is better to reach a mutual understanding than creating a dispute which will ultimately go to a court of law. And it's also important at this stage to seek proper legal advice. Now, coming to what if your contract does not contain a force majeure clause. Now, this is a possibility. We always ensure that our clients have force majeure clauses in their contracts because it's very important in times like these. However, we've come across cases where a lot of times clients don't have force majeure in their contracts. So, not a problem. It does not mean that the parties are remediless. There is a remedy provided under the Indian Contract Act, and that is your Section 56, which also is called as the doctrine of frustration. Now, I read Section 56, and it says, and I quote, a contract to do an act which later becomes impossible due to an event which the parties could not prevent becomes void when the performance becomes impossible. So this is a remedy provided by the Indian Contract Act in cases where the parties don't have a force majeure, well-drafted force majeure clause in their contract. For Section 56, we also have a landmark case decided by the Honorable Supreme Court all the way back in 1954. This was the case of Satyabrata Ghosh versus Mugni Ram, Bangur and Co. In this case, the Supreme Court has decided when it is possible to seek relief under Section 56, and it says relief can be sought under Section 56 if the performance has become impracticable and useless from the point of view of the object and purpose which the parties had in view at the time of entering into the contract. So this is very important to keep in mind. Now moving to the second important aspect, which is the impact of COVID-19 on rental agreements and rental obligations. Now, looking at the current situation where the businesses are shut and there's a lockdown enforced, a lot of people are worried about rental obligations. The landlords and licensors are worried about receiving timely payments of rental obligations, while the tenants and licensees are looking at ways and legal avenues of deferring payments. So there are two important aspects under rental obligations. One is your lease, that is between your landlord and your tenant, and the other one is the leave and license between licensee and licensor. Now, starting with lease. Now, lease of any immovable property is defined under the Transfer of Property Act under Section 105. Now, this is very important. The Transfer of Property Act is a special act which governs with immovable property, transfer of immovable property, and lease is included in this act. So under Section 108 of the Transfer of Property Act, it provides for a particular condition, and only if that particular condition is satisfied, the lease can be rendered void and not otherwise. So that particular condition is that the property, which is the lease property, must be completely destroyed. Now it can be by events like a fire or any other natural calamity or any other event, but unless the property itself is completely destroyed, it is not possible to set aside a lease agreement. And the tenant is duty bound to keep paying the rental obligation. So in a situation like this, wherein the office obviously your property would obviously be in good condition, but there is a business problem faced by everyone. There is a lockdown, there are financial crises. So these conditions are not good enough to set aside your lease agreement, and the tenants will have to pay their rental obligations, rental payments on time. Now, because this is a special act, the doctrine of frustration, which we discussed earlier under Section 56, is not applicable, because the Contract Act is a special act. Sorry, the Contract Act is a general law, while the Transfer of Property Act is a special act dealing with a particular aspect. So whenever there is we have a confrontation between special and general laws, the special statutes will always prevail over the general laws. Hence, you cannot seek the relief under doctrine of frustration, and you have to make sure the conditions specified in Transfer of Property Act are satisfied. However, there is a possibility that there is a well-drafted force majeure clause in your lease agreement. And if that is so, and that particular clause contemplates conditions, force majeure events like pandemics or lockdowns, then that particular clause will prevail, and the payment can be deferred, or the lease agreement could be set aside. Now, coming to a directive that was passed by the Maharashtra State Housing Department, which was passed recently on 17th April. It gave directives to landlords to not collect rents for a period of 3 months. And the tenants should not be evicted from their premises for non-payment of rents during this time. Now, what is important to understand is that this is only an order for deferment of rent collection and not a waiver of rent, which means after 3 months, the landlord is entitled to receive the rent which was not paid for these 3 months. So they can have an extra collection proportionately. Also, what is important to understand is that this particular order of the government of Maharashtra is applicable only to residential properties, and it is not applicable to commercial properties or premises. And it is unlikely that the government would come up with orders which would be dealing with the commercial or business transactions between parties. So this is only applicable to residential premises. Then we come to another order dealing with rental obligations, which was passed on 29th March by the Ministry of Home Affairs, Government of India. And this particular order was passed under the provisions of a particular act, which is the Disaster Management Act. Now, this order has directed the landlords to not collect payment of rent from workers, from people who can be classified as workers for a period of 1 month. It also directed the landlords to not evict students and workers from the premises for non-payment of rents during this time. And because this order was passed under a statute, which is the Disaster Management Act, which provides for a penal provision on violation of this order, those landlords who are in defiance can be penalized under the provisions of the Disaster Management Act, especially under Section 51B of the Act. And I quote, "Whoever refuses to comply with the direction given by or on behalf of the central government or the state government or the National Executive Committee or the State Executive Committee or the district authority under this act shall on conviction be punishable with imprisonment for a term which may extend to 1 year or with fine or with both." So landlords who are violating this order can face imprisonment as per the provisions of this particular act for not obeying this particular order. However, we have read of instances where knowingly or unknowingly some landlords have violated this order, and one advocate in New Delhi has recently moved the Supreme Court with a petition to get this order implemented against those landlords. So it will be interesting to see what orders are passed by the Honorable Supreme Court in this regards. So that was lease. Now we come to leave and license, which is the other aspect under rental obligations. So to begin with, what is a license? Now, a license is basically the understanding between the licensor and the licensee under a license agreement. And a license is nothing but a permission given by the licensor to the licensee to occupy and use the licensed premises for the purposes as may be given in the the license agreement. Now, this particular aspect is not governed by the Transfer of Property Act, as it was in the case of lease, because under a leave and license agreement, there is no transfer of interest, especially possession, in favor of the licensee. The possession is always with the licensor, and the licensee is merely permitted to use the premises. Hence, in such a scenario, relief could be sought under Section 56 of the Contract Act, which is your doctrine of frustration, as I explained earlier. The best scenario obviously would be that your license agreement has a force majeure clause which contemplates government lockdowns and epidemics to invoke that force majeure clause to defer payments or set aside your agreement. The best thing to do is to obviously reach a mutual understanding with your licensor or your tenant, your landlord in case of your lease agreement to defer the payment. Third, we have another concept which is called co-working spaces. This is a relatively new concept. Most of us must have heard of places like WeWork or establishments like Regis centers. So these are basically centers which are managed by their own management, and their customers are permitted to use their premises only for a fixed number of hours, and depending on the stipulated conditions as may be mentioned in their agreements. Now, this is slightly different from your leave-in license and lease, because in the former cases, the duty of the landlord or the licensor is only to hand over possession, and then it is the obligation of the other party to continue paying, regular payments of rental obligations. But in this scenario, in co-working spaces, it is the active duty of the management to provide unhindered entrance and access to the premises. And if the management is not able to provide access, especially in time of this current lockdown, then obviously the force majeure clause should be invoked and they should not collect payments from their clients. Alternatively, obviously, there is Section 56 again, which can be utilized to seek reliefs. Now we come to the third aspect, which is again very important, which deals with employment-related concerns in light of COVID-19. Now, as we know, because of this lockdown, our economy has almost come to a near standstill. So a lot of corporates, a lot of business houses, a lot of employers are considering different methods, avenues, and looking at the legality to reduce their financial stress, as the businesses are anyways not functional. Some of the methods are salary reductions, layoffs, and even termination of employees. Now, what is important to understand in such a scenario is that there are certain orders passed by the government. There are some important employment laws in place in our country. So the concerned employer must always be aware of the implications of these laws and orders. So what are they? To begin with, let's discuss the first order that was passed by the Ministry of Home Affairs, which I had discussed earlier as well. So this particular order, which was passed under the Disaster Management Act, it also contemplates for deduction of wages. So it is applicable to all employers who are in any industry, shop, or commercial establishment. And this particular order directs the employers to not deduct wages of their workers till the time the lockdown is in force, and that they should make the payment on time. There should not be any delay in payment as well. There was another resolution passed by the government of Maharashtra on 31st March 2020, which was applicable to public as well as private employers. Again, the employers were called upon to not deduct wages of their workers and to make payment on time till the time the lockdown is in force. Now, what is important to understand is whether these orders are applicable to all employees, all classes of employees. Then the answer is no. It is not applicable to all your employees. It is only applicable to a certain class of employees who are your workers, and your certain employees like your management level staff, your administrative level staff are not governed, are not within the ambit of these orders and your employment laws. So their contractual, their employment can be decided as per their individual employment agreements. Now, what is again important to understand is that this order has been passed again under the provisions of the Disaster Management Act, which has a penal provision. So if any employer is deducting salaries or wages of the workers who are considered within the ambit of this order, will be penalized and could also face imprisonment. So it is very important to seek proper legal advice if you are contemplating on such steps, to understand which employees or which workers fall under this criteria. Now, what is important to understand is that these orders are applicable only till the time the lockdown is in force. They clearly mention till the time the lockdown is in force, you cannot deduct payment. So once the lockdown is recalled, you can deduct payments of even the workers who fall within the ambit of these orders. However, you have to obviously make sure you're following the provisions of various employment laws like Industrial Disputes Act, Minimum Wages Act, which are applicable to these workers. Now, coming to this, on the other side, there was a petition filed in the Honorable Supreme Court recently by one textile mill based in Mumbai. Now, this petition has challenged this particular order of the Ministry of Home Affairs, saying it's an arbitrary order, and it is a violation of Article 14 as well as Article 19. And the petitioner has sought relief wherein it has asked the Supreme Court to set this order aside, as it is not practically possible for the particular company or corporates in general to keep paying the full salaries to their employees, especially when the businesses are not functional. So again, it will be an interesting scenario, and we should see what the Supreme Court comes up with and what orders are passed. And finally, then we come to the insolvency landscape of corporate India. Now, this especially in view of the increase in the threshold of default by the Ministry of Corporate Affairs. So, as many of us are aware, on 24th March 2020, the Ministry of Home Affairs increased the threshold of default under the IBC by 100 times, which means from the previous threshold of rupees 1 lakh, it has now been increased to rupees 1 crore. Which in other words means if anyone is contemplating action or proceedings under the Insolvency and Bankruptcy Code, now cannot invoke these provisions and cannot file insolvency proceedings unless they have receivables amounting to rupees 1 crore. This has obviously brought unrest amongst a lot of creditors who were contemplating on filing or initiating insolvency proceedings against their corporate defaulters for non-payment of dues. So what has to be seen is whether this move of the Ministry of Corporate Affairs is productive or counterproductive. Now, from what we understand, this particular move was taken only to protect rights of the corporates, especially the MSME sector, who were obviously more likely to commit defaults on their payments and obligations due to the current lockdown and shutting of businesses. So it is a measure to make sure these MSMEs and corporates are not dragged to insolvency. However, there is an understanding, or it is said that this move may not be a temporary move and it could be a permanent move. Now, if it is a permanent move, then we'll have to again consider whether it's productive or counterproductive, because it would defeat the very purpose of the Insolvency and Bankruptcy Code. So coming to the next point, which is dealing with suspension of insolvency proceedings. Now, lately we've heard that the government, the Ministry of Corporate Affairs has taken a decision. The central government has taken a decision to suspend altogether the initiation of insolvency proceedings under Section 7, which is by your financial creditors, under Section 9, which is by your operational creditors, and as well as Section 10, which is by the corporate defaulter itself. Now, they are contemplating on suspending insolvency proceedings for a period of 6 months to 1 year, ranging from 6 months to 1 year. This would be obviously done with a view to provide some respite to corporates who would be on the verge of committing defaults due to shutting of businesses and lockdown. So this brings us to the question, if IBC cannot be utilized, proceedings cannot be utilized under the Insolvency and Bankruptcy Code, then what are the alternatives? Now, what is to be important, what is to be understood here is that when IBC was framed, it wasn't meant as to be a tool for recovery. It was not a tool for recovery, but a lot of corporates, including banks, utilized IBC proceedings with only a sole intention to recover their monies or to reach a settlement, even though that is not contemplated by the code itself. So for people who are now looking at other alternatives to recover their money, what is the best options available to them? From my understanding, we have two good options, which are effective as well as time, as well as not lengthy. The first proceeding, the first aspect is proceedings under the Micro, Small and Medium Enterprises, that is your MSME Act. Now, proceedings could be initiated under these acts by MSME, by registered MSMEs who hold Udyog Aadhaar. They can be initiated to recover their money. So some of these provisions which are important under the acts, I shall be discussing them. For example, you have Section 15 of the MSME Act, which deals with micro and small enterprises. Medium enterprises are not included. So what it says is that whenever there is a purchase and sale transaction with micro or small enterprises, wherein the micro or small enterprises has given services or provided goods, then the payment should be made to them within an overall period of 45 days only. Obviously, the parties can decide on a shorter timeline, but it cannot be more than 45 days. Section 15 of the Act also says whenever the parties have not agreed to any payment date, then the payment has to be made to these micro and small enterprises within just 15 days of seeking the products or services. Now, if there is a violation and the payment is not made as per Section 15, then compound interest would be charged to the defaulter, which would be 3 times the rate charged by banks as notified by the RBI. There is also a remedy provided to these micro and small enterprises wherein they can file their complaints or refer their matters for recovery to the Facilitation Council. Now, there is a council constituted under this Act to hear cases on behalf of micro and small enterprises. So any disputes can be referred to them by micro and small enterprises, and the council would then hear both the parties and try to reach a settlement between them, wherein the payment could be made to the micro and small enterprises. However, if there is no settlement under conciliation, then the dispute will be referred to arbitration. And the arbitrator then has to pass an award within just 90 days from receiving the reference from the council, or the council itself can conduct the arbitration proceedings. What again is important is that there is a government portal, an online government portal called Samadhan Portal, which is made by the government of India. So micro and small enterprises who are facing payment problems, wherein they are not receiving their payments on time, they could lodge their complaints with this portal, and this portal will then transfer or forward the complaints to the concerned council, depending on the jurisdiction, who will then take it forward and decide the matter. Another important aspect in this is whenever there is an order passed by the council or by the arbitrator, and if there is an appeal to be filed by the other party, being the defendant, then he cannot file such an appeal unless he deposits in the appeal court an amount which is amounting to 75% of the award, or the amount which he has to pay to the micro or small enterprises. So he has to deposit this amount in court, and only then his appeal would be heard. So this was one effective way which parties can consider to get their payments, especially the micro and small enterprises. Now we have a second alternative which can be utilized by micro and small enterprises, as well as medium and other corporates who do not fall under the criteria of micro and small enterprises. That is your summary suits. Now, summary suit is again one of the good alternatives to IBC. Now, summary suit is basically is a suit that is filed for recovery of liquidated debts. Now, this liquidated sums can be understood, can be quantified through your invoices, your agreements, and so on. And unlike a regular suit, whenever you file a summary suit for recovery of your liquidated sums, the defendant or the defaulter in this case does not have a legal right to defend his case, unlike the regular suit. So the defendant has to mark his presence before the court within a timeline as provided, that is 10 days from receiving summons, and he has to seek the court's permission to defend. And if the court is not satisfied with the argument put forth for or the reasons given to defend the case, the defendant or the defaulter is not permitted to defend his case, and a judgment is straight away passed in favor of the creditor or the plaintiff in this case for the sum that is due and payable. And there are various other aspects of summary suits which are time bound. So it altogether makes it a very economical and quick remedy and a good alternative to the insolvency and bankruptcy proceedings. So these were a few aspects which I discussed in short regarding the current, regarding some important aspects of law which employers, corporates, tenants, landlords, everyone should keep in mind. And with this, I come to the end of my presentation. And also, I believe, as it said, that in every adversity, there is also an opportunity. So I think from what I see, this is applicable to the current times as well. We have seen a lot of corporates, a lot of international corporates who are contemplating on moving out of China. So India is a good option for these so-called international giants to come and establish their plants and set up their factories, which will obviously boost our economy. We have recently seen partnerships happening, big partnerships like that of Facebook and Reliance Jio. So we are looking at a lot of possibilities of future mergers and acquisitions with between different companies, which obviously would be beneficial for our economy. So let's hope for the best and keep supporting each other in these difficult times. It is also important to be aware about updates in laws and different government circulars and notifications which are coming out, which will have an impact on your particular sector of work. So with that, I end my presentation and thank you everyone. Please stay safe and stay home and stay safe. Back to you, Dipesh.
Thank you, Nihar. Thank you so much. So it was really a compressed, condensed, but a very powerful presentation. And thank you so much for all the information that you've given. We have recorded this presentation. So we will be posting the link on IBG's group. So everyone will be able to see this later on. Now, time for some quick questions. So people can put their questions in the chat window and I will ask them to Nihar. Okay. So Rishi Raj has asked, if during the term of license, as a result of national emergency, riots, general strikes, war, or fire, the licensee is unable to have access to the use of licensed premises or is unable to have access thereto on account of force majeure clauses, returning in loss or destruction of the said licensed premises, the obligation of the licensee to pay the compensation to the licensor under this agreement shall be suspended. Nihar, can you, it's a long question. You can see it in the chat window.
Yes, can you hear me?
Yes.
Yes, 1 minute. Could you repeat the question, please? I'm having
it's a very long question. Just open your chat window, you'll be able to read.
Okay. So basically, from what I understand,
shorter questions, yeah.
From what I understand, 1 minute. Let me just open the question. If during the term of the license, as a result of national so that on account of force majeure clause resulting in loss or destruction of the national license. So, first of all, what we have to understand in this scenario is that this is a even license agreement and not a lease agreement, which is provided under the Transfer of Property Act. So, in such a scenario, you can always seek relief under your force majeure clause. So, if there is a force majeure clause which provides deferment of license payment or the payment of fees, then obviously, yes, the licensee could invoke that clause and defer the payment as provided therein. If there is no force majeure clause, then like I said, since it's a leave-in license, and the licensee can always take shelter again under Section 56 of the Indian Contract Act, which is also called your doctrine of frustration. However, the best thing to do in this scenario, I believe, is to reach a mutual understanding between the licensee and the licensor, wherein the licensor could, the parties could mutually agree to deferment of payment, and maybe they could agree to some interest payment or something on those lines to compensate the licensors at a later time.
Cool. So Nihar, there is a following question that Rishi Raj has asked, and he has asked, is COVID-19 a national emergency?
Yes, like I said, there are two things to this. One, it will depend on your force majeure clause, when it's applicable to your particular contract. If your force majeure clause is wide enough to have within its ambit such a national calamity, then yes, the lockdown or the pandemic will be considered as as an act of God or force majeure. Now, there was a recent circular also by the government of India, wherein for government companies, it has said, it has declared that such an event, this particular pandemic, will be treated as a natural calamity. And those particular government companies have been given the privilege to invoke force majeure and set aside the obligations. So the government is considering this event as a force majeure or act of God.
Awesome.
But that is only applicable to government employees. Your contract, the private contracts, will depend on the particular force majeure clause and the understanding of the parties.
All right. Thank you. Can Section 56 really apply to leave and license agreements in this situation? Because frustration applies only to permanent unlawfulness. Can you see this question, Nihar?
1 minute.
Shamant has written this question.
So the reason why I'm saying 56 will be applicable to leave and license agreements is because it is not a lease agreement as contemplated under the Transfer of Property Act. So leave and license is not governed by that particular special act. Hence, it will be governed by a general act. Again, it revolves around 3-4 aspects, which is whether you have a force majeure clause or not. That will govern the entire transaction between the parties. If, say, worst case scenario, you don't have a force majeure clause and you are not able to reach a mutual understanding with your licensor, then you don't have an option but to seek relief under Section 56. And then if there is a dispute, you will have to fight it out before a court of law. And then we'll have to see how the court interprets this and how what orders are passed. But the best solution is to reach a mutual understanding. There is no point in going to a court of law. And always, while you enter a contract, please make sure proper legal assistance is taken and a proper force majeure agreement clause is drafted.
All right. Thank you. What is the procedure to file a complaint for non-payment under MSME Act?
Okay. So, like I said, under MSME Act, if you want to avail the provisions of the MSME Act, then you can only do it if you are a micro or a small enterprise. Medium enterprises and above are not permitted to file complaints to the council. So what happens is, first of all, you have to make sure that you are a micro or small enterprise. There is a criteria given under the MSME Act. You will also have to make sure you have a valid Udyog Aadhaar. So you have to register for that business Aadhaar. And only then you can file a complaint with the Facilitation Council, which is constituted under the Act. Now, which council to approach will depend on the concerned jurisdiction. Also, what I feel is the best way is to utilize the online portal. So if you're a micro or a small enterprise, you can utilize the online portal, which is the Samadhan portal, and lodge your complaints there. And the portal itself will forward it to the concerned Facilitation Council for the action.
All right. Thank you. I own a restaurant business on lease. How do I avoid payment of rent?
Okay. Now, when you say lease, I presume it's a lease agreement and not a leave and license agreement. Right. So, like I said, it is very important to understand one aspect, which is lease is governed by the Transfer of Property Act. And there is a particular condition provided under Section 108 of that Act, which says unless the property is rendered destroyed, you cannot take action to set aside your lease agreement. So only in conditions like where there's a lockdown or where there's a financial difficulty, it is not possible to invoke force majeure and obviously you cannot seek relief under Section 56, like I said. It is only under Section 108. Also, but what can happen is that you could have a well-defined force majeure clause. So if you have a force majeure clause and the parties have agreed that even in conditions where the property is well intact, but there is a financial difficulty because of lockdowns, quarantines, epidemics, then yes, there could be a deferment. Parties can reach that understanding. And if there is a force majeure clause, then that will prevail over every other things. If there is no force majeure clause, you don't have an option. You are bound by the provisions of Section 108.
All right. So yeah, somebody had asked a question, what if lease deed has a force majeure clause, but you've just answered it. So that's good. Yeah. Nihar, do you want to quickly go through the window and see if any other question you can take?
Okay.
We have like another 5 minutes.
So there is a question dealing with which employees are protected under the law and how to deduct their salaries. Okay, like I said, the government orders which I spoke of earlier, maybe the order of the Maharashtra government or orders of the Ministry of Home Affairs, they deal with only a particular class of employees and not all employees basically. So to understand which are these employees or workers rather who fall under the ambit of these orders, you have to refer to provisions and definitions provided under various employment laws. Some of them are your Industrial Disputes Act, your Minimum Wages Act. So workers who are classified as workers under these provisions, under these laws, are falling within that ambit and not the other employees. Obviously, if you have this particular query, you could obviously get in touch with us offline and we could discuss this in more detail as to what the various laws provide and who are these employees.
All right, thank you. Any other? Nihar, take one more question and then I'm going to put your email ID in the message block so people can reach you directly.
Sure. Most of the questions that I'm seeing are dealing with...
answer them.
Yes. So what I suggest is, since I've answered most of the questions because they are revolving around the same line, ID is present, and whoever has a specific query can obviously get in touch with me or my firm, and we'll be more than happy to take it forward from there.
Certainly. So I've put your email address, website address on the chat. Do you want me to put your mobile number as well?
Sure, not a problem.
Oh, I have done that. All right. So before we say goodbye, I would like to invite Priya to say a few words. And Priya, I have unmuted you.
Yeah. Hi, Nihar. First of all, thanks a lot for such a wonderful talk. I'm sure all of us over here got really good insights on your topic. And finally, thanks a lot to all our members for being such a good audience. Next week, let me meet on Friday with a new topic. And yeah, see you soon.
Absolutely, my pleasure, and thank you everyone. Thank you Dipesh, thank you Vikashji, Priya, and the entire team at IBG, and thank you everyone for your time. And hopefully we'll connect again soon.
Certainly. Vikash, some closing remarks.
Yes, this is really wonderful. I think we should be doing much more of this. Let's, as Priya said, that every Friday let's do a webinar.
Yes.
On some special topic.
Yes.
And thank you, Nihar, for all this.
Thank you.
All right, guys. Thank you once again, Nihar, for your time and your wonderful information. I'm sure you'll get a lot of questions and queries from our members. And thank you so much, guys, for listening into the webinar and participating, asking questions. It's very important to be interactive, and thanks for doing that. So until next time, goodbye, take care, stay safe.
Thank you.